Good day to everyone. Today, I'm going to discuss Rule 119, Trial, Section 4, 5, and 6. First, Section 4, Factors for Granting Continuance. The following factors, among others, shall be considered by a court in determining whether to grant a continuance under Section 3, letter F of this rule. Whether or not the failure to grant a continuance in the proceeding would likely make a continuation of such proceeding impossible or result in a miscarriage of justice. Likelihood impossibility of miscarriage of justice. This factor highlights the importance of ensuring that the denial of continuance does not make it impossible to continue the legal proceedings or result in a miscarriage of justice. In other words, if proceeding without continuance would fundamentally compromise the fairness of the trial or the ability of the parties to present their cases properly, then a continuance may be warranted. Next, we have the letter B. Whether or not the case taken as a whole is so novel, unusual, and complex due to the number of accused or the nature of the prosecution, or that is unreasonable to expect adequate preparation without the periods of time established therein. So the complexity of the case, if the case is deemed to be exceptional, novel, unusual, complex due to the factors such as the number of accused or the nature of the prosecution, it may warrant a continuance. This factor recognizes that a certain cases required more time for adequate preparation and presentation due to their intricate nature. In addition, no continuance under Section 3, letter F of this rule shall be granted because of congestion of the court's calendar or lack of diligent preparation or failure to obtain available witnesses on the part of the prosecutor. In summary, these factors aim to guide courts in making informed decisions about whether to grant continuances, balancing the need of fair trial, of fair and efficient legal proceedings with the rights of the parties involved under the Philippine law. Next, we have the Section 5. Time limit following an order for new trial. If the accused is to be tried again pursuant to an order for a new trial, the trial shall commence within 30 days from notice of the order, provided that if the period becomes impractical due to unavailability of witnesses and other factors, the court may extend it but not to exceed 180 days from notice of said order for a new trial. So the commencement of trial within 30 days, when an accused is subject to retrial because of an order for a new trial, the trial must within 30 days from the date the order is served or officially communicated to the parties involved. This time frame ensures a swift resumption of legal proceedings, maintaining the integrity and efficiency of the justice system. The extension of time limit up to 180 days. However, if circumstances arise that render it impractical to start the trial within the initial 30-day period, such as the unavailability of essential witnesses or other compelling factors, the court has the authority to extend the time limit. The extension cannot exceed 180 days from the date the order of a new trial is served or officially communicated. So I do hope, guys, that the Section 5 is very clear to each and everyone. Okay, now let us proceed to Section 6, Extended Time Limit. Notwithstanding the provisions of Section 1, Rule 116, and the preceding Section 1, for the first 12 calendar period following its effectivity on September 15, 1998, the time limit with respect to the period from arraignment to trial imposed by said provision shall be 180 days. For the second 12-month period, the limit shall be 120 days, and for the third 12-month period, the time limit shall be 80 days. Arraignment of trial time limit. Normally under section 1, letter G of Rule 116, there's a time limit prescribed for the period from arraignment to trial. However, section 6 introduces an extended time limit for specific durations following the effectivity of the law. The extended time limits. For the first 12 calendar month period from the laws effective on September 15, 1998, the time limit for the period from arraignment to trial is set at 180 days. This means that the prosecution must conclude the trial within 180 days of the accused arraignment during this initial period. For the second 12 month following the law's effectivity, the time limit is reduced to 120 days, and for the 12-month period, the time limit is further reduced to 80 days. The gradual reduction of time limits. The provision outlines a gradual reduction in the time limit for the period of arraignment to trial over the course of 3 consecutive 12-month periods. This suggests an expectation of increased efficiency and streamlining of legal proceedings as the system becomes more accustomed to the prescribed time frames. So these provisions aims to gradually transition the legal system towards expedient trial processes, encouraging timely resolutions of cases while allowing for an initial adjustment period following the enactment of the law. So that's conclude my report under the Rule 119 trial from section 4, 5, and 6, and I do hope that you guys can learn into my discussion this today, and my discussion is only based on my personal knowledge and understanding to what I have read in Rule 119. So I do hope that you respect my opinion because I'm just a student. I am a student and not a lawyer. So guys, thank you so much for your time and thank you for listening. Always, God bless and always take care.
Good day everyone, my report is all about Rule 119, Section 4, 5, and 6. Section 4, Factors for Granting Continuance. In legal proceedings, the decision to grant a continuance under Section 3 of Rule 38 to 39 is contingent upon several factors outlined in Section 4. Firstly, courts must assess whether denying a continuance would render the continuation of the proceeding impossible or lead to a miscarriage of justice. This consideration underscores the importance of ensuring fair and effective adjudication, weighing the rights of the accused against the need for procedural efficiency. Secondly, the complexity of the case, including factors such as the novelty, unusualness, or complexity due to the number of accused or the nature of the prosecution, plays a crucial role. If the case presents significant challenges that impede adequate preparation within the prescribed time frames, granting a continuance may be justified to uphold the principles of due process. However, it's notable that continuance cannot be granted solely due to congestion of the court's calendar or lack of diligent preparation by the prosecutor. This provision underscores the importance of the judicial efficiency and accountability, discouraging delays caused by administrative reasons or negligence. Moreover, in cases where a new trial is ordered Section 5. Section 5, the time limit following an order for a new trial. Section 5 impose a time limit of 30 days for the trial to commence from the notice of the order. This provision emphasizes the expeditious resolution of legal proceedings, ensuring timely justice for all parties involved. Nevertheless, the court may extend this period up to 180 days if impractical due to factors such as witness unavailability, balancing the need for expediency with fairness. Additionally, Section 6. Section 6 extended time limit. Section 6 introduced extended time limits for the period from arraignment to trial during the initial 3 to 12 months periods. Following the rules effectively, this progressive reduction in time limits reflect an attempt to streamline legal process while adjusting to practical challenges and feedback from implementation. In summary, the factors for granting continuance and time limits in legal proceedings aim to strike a delicate balance between expeditious resolution and the protection of procedural fairness and due process rights. By considering the complexity of the case, potential miscarriage of justice, and practical constraints, courts can uphold the integrity of the legal system while ensuring timely and effective adjudication.
Good day everyone, my name is Alvin Palsado. My reporting is all about Section 4, 5, and 6. The first is Section 4, Factors for Granting Continuance. The following factors, among others, should be considered by a court in determining whether to grant continuance under Section 3 of this rule. When a court is determining whether to grant a continuance under Section 3 of a rule, it considers several factors. One of the key factors is whether or not the failure to grant a continuance is the proceeding would likely make a continuation of such proceeding impossible or result in miscarriage of justice. In addition, the court will not grant a continuance due to congestion of the court calendar, lack of diligent preparation, or failure to obtain available witnesses on the part of the prosecutor. These factors are considered to ensure that the justice process is fair and efficient and that all parties involved have adequate time and resources to prepare their case. A. Whether or not the failure to grant a continuance is the proceeding would likely make a continuation of such proceeding impossible or result in miscarriage of justice. This means the court is considering if not delaying the court case could lead to unfair trial or make it impossible to proceed with the trial. The court wants to ensure the trial is fair and just, so it will consider this seriously. Letter B. Whether or not the case taken as a whole is so novel and unusual and complex due to the number of accused or the nature of the prosecution or that is unreasonable to expect. Adequate preparation within the period of time established therein. This factor consider with the case is exceptionally unique, unusual, or complex either due to the number of accused individuals involved or the nature of the prosecution. It's also assessed if it would be unreasonable to expect proper preparation within the specified time limit. In simpler terms, is the case is very complicated, involving many accused individual or intricate legal matters and the time given for preparation is insufficient, a continuance may be granted to allow for adequate preparation and ensure a fair legal process. In addition, no continuance under Section 3 of this rule should be granted because of congestion of the court calendar or lack of diligent preparation or failure to obtain available witnesses on the part of prosecutor. The second is Section 5. Time limit following an order for new trial. If the accused is to be tried again pursuant to an order for a new trial, the trial commence within 30 days from notice of the order, provided that if the period becomes impractical due to the unavailability witnesses and other factor, the court may extend it but not to exceed 180 days from the notice of said order for a new trial. If the accused is to retried based on the court order for a new trial, the trial must begin within 30 days from the notice of the order. However, if starting the trial within this initial period is not feasible due to reason like witnesses unavailability, the court has the authority to extend the time limit. This extension shall be not exceed 180 days from the notice of the order for a new trial. This provision is ensured that the retrial process is conducted promptly while allowing flexibility for practical consideration that may arise. The third and the last, Section 6, Extended Time Limit. Notwithstanding the provision of the Section 1, Rule 116 and the preceding Section 1, for the first 12 calendar month period following its effectivity on September 15, 1998. The time limit with respect to the period from arraignment to trial exposed by said provision should be 180 days. For the second 12-month period, the time limit shall be 120 days, and for the third 12-month period, the time limit shall be 80 days. This section outlines the extended time limit for the period from arraignment to trial, debating from the standard provision of Rule 116 in the initial 12 calendar month period following the rule enforcement on September 15, 1998. The time limit for this phase is set at 180 days. Subsequently, in the second 12-month period, the time limit is reduced to 120 days and further decreased to 80 days. For the third 12-month period, this progressive reduction aims to expedite legal proceeding and ensure time resolution of criminal cases. Thank you.
Good afternoon, ma'am. This report will tackle the Section 4, 5, and 6 of Rule 119 on trial. First, the Section 4, entitled Factors for Granting Continuance. In this section, it discusses that and says that the court shall consider various factors in deciding whether to grant a continuance under Section 3 of this rule. This includes, first, the risk of miscarriage of justice if a continuance is not granted. Letter B, the complexity of the case due to the number of accused or the nature of the prosecution made it unreasonable to expect adequate preparation with established time frames. This means that the court may not grant a continuance due to court calendar congestion, meaning many court trials and the court is not available on that time. Lack of diligent preparation, or the trial is not properly prepared, so the court cannot do it on the said time. And last, failure to secure available witness by the prosecutor. This means that the prosecutor look for witness and unfortunately the prosecutor cannot provide or secure a witness for the case. That's all for section 4. Next is section 5. Time limit following an order for new trial. In this section, it tells us that if a new trial is ordered, the trial must commence or happen within 30 days from the notice of order. So, if the notice of order is released, meaning within 30 days or after 30 days, the trial must be already done. If this period becomes impractical or impossible to happen due to factors like unavailability of witness, and the court may extend time but not beyond 180 days from the notice of the trial order. Meaning the court will give you 180 days for you to make sure that the problem is solved, so that the trial will be happened or will be continued. Next is the section 6, extended time limit. For the 12 first month period following the rules effectivity of September 15, 1998, the time limit for arraignment to trial is 180 days. And for the second 12-month period, if the trial didn't happen in the first third period, it is 120 days only. So 60 days were subtracted, or less than 60 days. And for that 12-month period, in the third time, only 80 days will be allotted for the trial to commence or for the trial to be continued. That's all. Thank you, ma'am.